for listing,
Listing of what?
listing
Matter for
motion.
admission.
Motion.
Motion. When was it filed?
It was filed 26. Last date was 18/2.
That should be on
Service benefit.
10th of June.
15.
15th. Oh, 15th.
Right.
For adjournment of one for item number 48, so speak was circulated also. Although
48.
40, although oral consent was taken because they were not at vote yesterday.
Item 48 on the adjournment, the basis of the adjournment slip circulated, matter stands deferred. We listed after.
There is an interim in this matter. There is an interim in this
Interim order passed early will continue.
Lordship, can we fix the matter after 3 weeks, Lordship? Not 20.
After 4 weeks. Come on.
Lordship, before this.
No, not before. After beginning.
My lord, may I please for listing on next week matter and column.
Why? What is the
My
matter?
lord, in earlier occasion, it was listed on 8/5/2026. Before Honorable Justice Mr. Nair. But Lordship was not taking this matter and placed the matter before another bench. But that's why matter is not being listed.
17th.
Before my lord 16, my lord, I have to go outside.
15th.
Please, Your Lordship. I beg to mention item number 5, Your Lordship. Lordship, in this matter, the charge sheet has been filed, Your Lordship, and the petitioner has also furnished a reply. So, Your Lordship, we need to file a detailed affidavit in the matter.
This was the order recorded by your lordships while issuing notice of motion on 11/5. The matter relates to suspension of the continuing suspension of the petitioner. They've already taken 4 weeks. May I just pray that they will be given 2 weeks for the final chance for filing their affidavit? That's my humble request.
Yes.
Yes, Your Lordship, within 2 weeks, we'll file.
I'm appearing for respondent number 5.
However, Lordship, the
Week.
two
2 weeks will.
No, let the matter be fixed up in July, but they may file their response before the vacation. That's my humble request.
Any notices issued here?
Notice issued, Your Lordships. And
Notice
in fact,
issued.
yes, notice issued, and on the last occasion, that was my submission that the charge sheet has already been issued, and I have also filed my reply, my response. So there does not remain any reason for keeping him in the suspension.
Lordship, the IO in this matter was appointed and the disciplinary proceedings have also been initiated, Lordship. So there is no delay. Regarding the suspension, the same has also been reviewed by the 2-member committee, Lordship. Has been
Without
duly
any
extended
reasons.
also.
Without any reason. That is the entire case before Your Lordships.
MS so appearing for Mr. SCKL.
Yes, Your Lordship.
Prays for and is granted 2 weeks further time to complete instructions and file their counter affidavit as prayed for. Ms. R.S. Chaudhary, appearing for the writ petition, submits that the matter be listed immediately after 2 weeks so that effective orders can be passed in the matter. Considering the prayers made, release this matter on 17th of July.
Sorry.
By which date the respondent will file their
No,
affidavit.
not before that. Let them file it before the vacation. So that
The respondent will file the affidavit positively within 2 weeks,
Lordships.
and the petitioners will also have the liberty to file their rejoinder if so advised.
I'm deeply obliged to you.
Lordship, I'm appearing for respondent number 5.
MSP Agarwal appears for respondent 5.
Wait, please, Your Lordship. I beg to mention item, my lord, 31 and 38, my lord. Both the respective councils have been informed, my lord. Yes, sir.
31,
And 38.
31 and 38.
Yes, ma'am.
31 and 38.
Affidavit will be filed, my lord, in
Counsel for the respondent submits that matter be deferred. Renews his prayer for further time to file the affidavit. Prayer made not objected to by the counsel for the petition is least after 3 weeks.
Your Lordship, with respect to item number 38, Your Lordship, I pray for a date, Your Lordship, after vacation, suffice.
Let them file the affidavit.
Yes,
After
sir.
that, you make a mention, we'll fix a
Yes.
date.
Much obliged.
All right.
Maybe.
Yeah.
I beg to mention item number 54, my lord. I need some time, my lord. Second half of next week.
54. 54, Mr. H.R. Ahmed, counsel for the petitioner, prays for some time. How much? 2 weeks?
1 week.
1 week. Prays for a week's time. Matter be listed after 1 week.
Obliged.
Yes, Your Lordship, with the consent from the other council, I beg to mention item 51.
51.
Yes, Your Lordship.
Lord- Lordship, here I am appearing for the petitioner matter. There is an interim order, so that we can.
What is your prayer?
To be listed after vacation.
51 on the request made by the council for the respondent stands deferred to be listed after in the month of July. A date to be fixed by the registry. Interim orders, if any, passed early, will continue.
Your Lordship, another similar prayer for item 40 and 41, as the engaged council is unable to
40,
Here.
41 also again on the request made by the council for
water resource, Your Lordship.
water resources.
Right, so Lordship.
Have you informed the other side?
Yes.
Yes, I'm for 40 and 41. Kindly fix a date.
40, 41, no date, you have filed your affidavit.
Yes, Your Lordship.
Then why are you praying for an adjournment?
Your Lordship, the engaged council is unable to come because of some personal reason.
All right, 40, 41 to be relisted again
Nine.
on 20 July on the request made by the council for the respondents,
For holiday.
not before.
Yeah.
Yeah, please, Your Lordship. I beg to mention for petition column. Was last listed on 13/5/2026, Your Lordship. Due to paucity of time, Your Lordship.
17th June.
Please, Your Lordship, for listing of the case by law WPC 860/2021 on 17/6/2026.
Why?
My lord,
For admission,
for edit.
affidavit filed,
So all are.
filed.
All
All
are.
right.
And another matter, my lord, contempt case, my lord, Dipjyoti Sen, 2019 case.
17th, 17th.
Maybe
June.
listed on 19
No, 17th June.
of last, my lord.
I beg to mention item number 24. With the consent from the SS Roy Miller. SS Roy Miller, we have already obtained consent. Item number 24. Only for the accommodation for the day.
24 on the request made by Mr. A. Ahmed stands deferred to be listed after.
May I please? My lord, item number 37, my lord. I am appearing on behalf of dossier number 7, my lord. I have to file my lord affidavit in note.
You have taken consent of the
My
council.
lord, I could not, sir. My lord, able to inform. So I will, my lord, inform.
37 on the request made on behalf of the respondent number
7, my lord.
7 stands deferred to be listed after 2 weeks. It is submitted that the consent, the council for the petitioner, the information of the adjournment will be conveyed to the council for the petitioner. Interim order, if any, passed early, will continue. Yeah.
May I please, Lordship. I'd like to mention for urgent listing for contempt petition on account of expiry of the returnable date. My Lord,
That's not urgency.
there's a writ appeal emanating from the same order.
Maybe, but
and it will be
contempt
heard on
petition,
8th
there's
of
no
June.
urgency.
My Lords,
Contempt petition, there's no urgency.
My Lords, if
When
the
was it
writ
last
appeal-
listed?
11th
11th of
11/5.
11/5.
Yes.
So what is the urgency?
My
When
Lords,
was
if,
the returnable date?
on 8th of June, the writ appeal emanating from the same writ petition is being heard in the Chief Justice's court. And if the matter is disposed on that day, this contempt becomes infirm.
So that is how the course of law flows. If the writ appeal takes away the basis of the contempt, then the contempt has to be closed. In any event of the matter, there's a writ appeal pending, so we can't dispose of the matter. It's not proper to dispose of the matter.
Right.
You make a mention after the writ appeal is disposed of. Yes.
Lordship, I beg to mention, matter for listing petition in the admission column,
When was it last listed?
2910.
29/10. Then come back in July. List in July. 22nd July.
So Lordship, there is a content news. That orders follow.
Yeah, 22nd July.
There is a
Lordship, the fresh, legible copy.
Where is the relevant portion? Where is the relevant portion?
Lordship. The relevant portion is the CEO Jila Parishad Lordship.
SOIWT.
Lordship. This is 12. The department has submitted one number of proposal for the post of tax collector. Proposal for the post of grade 4 for appointment on compassionate ground. The committee examined the proposal in respect of so and so.
Expiry of 2 years.
IWT to the Director IWT Lordship Purnima Bala Rai, wife of late Gul Bahadur Rai, Khalasi ex IWT Assam for grade 4 post appointment on compassionate ground. Filed his letter number so and so. As per order of Honorable Court in WPC number so and so, the proposal was placed in district level committee meeting held on 26/2018. The district level committee examined the proposal and not recommended due to 2 years validity period is already over. It is mentioned here that the proposal was placed in the state level committee where it was not recommended for appointment due to non-availability of vacancy.
When did the petitioner file? Other expire?
It was in
6, 10, 11.
11, Lord. But as per this Fajirun Nask case, Lordship, this validity period of 2 years is there. And this is,
2 years from the date of death.
if it is kept pending for 2 years, Lordship. And accordingly, Lordship, this same has been reflected in the OM dated 1/6/2015, Lordship.
But there was some order of the High Court, 4099.
Regarding consideration.
Yes.
Yes, Lordship, this is of 2017. Yes, Lordship, the proposal of the placed in the district level committee, there is compliance of the order to consider, Lordship. So that's why it was placed before the DLC, Lordship. There is, as per order of the Honorable Court in WPC number so and so, the proposal was placed in district level committee meeting held on 26/2018.
Do you read page number 30?
Yes, Lordship, 30.
Last slide.
But
Last
as the director
paragraph,
wrongly
last slide.
forwarded the application
Or
to
you
the.
read the paragraph before that?
Acha, it is stated by the learned counsel for the petitioner that the claim of the petitioner for compassionate appointment originates in the Dhubri district and the claim ought to have been placed before the district level committee, Dhubri. Commissioner come so that it had never been placed before any district level. So
There is no fault on the part of the petitioner.
it was Dhubri, Lordship.
It was Dhubri, but it was sent to Kamru. Therefore, the delay. Now, the DLC says that it is delayed, but delay is not on account of the petitioner or anything. It is on account
So
of.
it's up to the department, Lordship, because they forward this.
That is right. But if it is Dhubri matter, you forward it to Kamrup and there's a delay.
So it's the department, they will look into this, Lordship. That in that regard, Lordship, I can't.
DLC
any
is for the
submission, Lord.
department. Yes. What is your instruction?
After we have taken the forwarded, suppose I'll take the complete instruction. My lord, the 2 years period, my lord, perhaps this for seeing whether the family, if the family is surviving for a longer period.
Do you have instructions or not?
No, no, my lord, I don't have instructions on this.
You
my
get your instructions
Fine.
as to when the matter was forwarded, the DLC to me.
lord. That is there, my lord, that is there in the instruction.
Hmm.
Not perhaps I'll take the complete.
We are not issuing notice.
Okay, ma'am.
Get your instructions.
Fine.
Third counsel for parties, the deference to the earlier order dated so and so. The learned state counsel is placed before the court. The minutes of the meeting of the DLC, Hubli, held on 2006-2018. So, at serial number Roman 11, regarding what is SO? Regarding under the heading sectional officer IWT Hubli. The DLC had recorded the finding that the proposal in respect of the petitioner was placed before the DLC in its meeting held on 2006-2018. And the DLC examined the proposal and had not made its recommendation due to the 2 years validity period being over. So, Learned State Council therefore submits that the claim of the petitioner was rejected by the DLC. The writ petition in the earlier round of litigation by order dated 14/7/2017, passed in WPC 4099 of 17, the writ petition filed by the writ petitioner earlier was disposed of with a direction to the respondent authorities to place the application for compassionate appointment of the petitioner before the next available committee in Dhubri. So, the said order, in the recital of the said order, the coordinate bench recorded the finding that the claim of the petitioner for compassionate appointment originates in Dhubri district, and the claim ought to have been placed before the DLC Dhubri, but the director wrongly forwarded the application to the Deputy Commissioner Kamrup, and the same was never placed before any DLC stop. Under such circumstances, the respondent was directed to place the application for compassionate appointment of the petitioner before the next available DLC to be stop. From the recital of the order, it appears that the application, the proposal for compassionate appointment of the petitioner was initially not placed before the DLC to be because of the same being wrongly sent to Kamrup by the director IWT. Stop pursuant to the orders of the coordinate bench, the matter was placed before the DLC. Then it appears that the DLC by order dated, by its minutes dated 2006-2018, rejected the claim of the writ petition and stop. Under such circumstances, it was now necessary to find out as to when the proposal was sent by the director for being placed before the DLC. And as to whether, what is that clause for the earlier notification? So which clause, the delay of 2 years is there?
Lordship,
Do you have that 15.9? Sorry,
yeah,
1.16.
2015. Lordship, I can give it after some time, Lordship, the hard copy.
As per the provisions of the OM dated 1/6/2015, all claims of professional appointment which were kept pending for 2 years are not to be considered again. And in that, in terms of that provision, the claim of the writ petition is rejected. Therefore, the standing counsel IWT is permitted to obtain required instructions and place it before the court within 3 weeks. The counsel will furnish extra copies. The counsel for petitioner will furnish extra copies to the standing counsel, respective standing counsel. This on 23rd.
I know.
23rd July. 23rd June, sorry.
23rd June. 23rd June. I'll let you know.
Yes,
The arbitration petition filed under section 11.6, 11.6C of Arbitration and Conciliation Act. If I may state the brief facts of the case, the
where is the clause for arbitration?
Lordship, if I may take your Lordship to section number 18 of Micro, Small and Medium Enterprises Act.
MSME Act. Yemen. Yes,
Lordship, section 18, if I may read.
18.
Yes, Lordship. Reference to Micro and Small Enterprises Facilitation Council, notwithstanding anything contained in any other law for the timing and force, any party to a dispute may, with regards to any amount due under section 17, may make a reference to Micro and Small Enterprises Facilitation Council. Now, subclause 4, Lordship, when a mediation initiated under subsection 3 is not successful and stands terminated without any settlement between the party, the council shall either itself take up the dispute for arbitration or refer it to any institution or center providing alternate dispute resolution service for such arbitration, and provisions of Arbitration and Conciliation Act 1996 shall then apply to the dispute as if the arbitration was in pursuant to an arbitration agreement referred to in subsection 1 of section 7 of that act. Now, Lordship, if I may read section 11.6C of the Arbitration and Conciliation Act.
Level
11.6C. Section 11, appointment to arbitrator. Any person or any of any nationality may be an arbitrator unless otherwise agreed to the party. Now, subsection 6 says, Lordship, where under an appointment provision agreed upon by the parties, subclause C, a person including an institution fails to perform any function entrusted to
you are
it.
reading 11.
6C.
subclause 6C.
When was it brought into the Act amendment?
There was no amendment, Lordship.
11.6.
Yeah, 11.6C.
Okay.
A person, including an institution, fails to perform any function entrusted to him or in any other procedures. So under the institution, MSME is an institution, Lordship. Also, I have a citation from Delhi High Court where it was held that
No, you tell us the facts, what happened before you go to the judgment.
Yes, Lordship, the facts of
So
the
you
case
are
is
you are an registered MSME.
MSME, and there
So
is
you entered into a contract
with
the
the
respondent.
respondents. Yes,
by
Lordship.
by which covenant, by which agreement?
Agreement dated 19/10/2020. Your Lordship will find it in page number 25.
25. Then
Pursuant to this agreement, we had supplied the equipments. The bills were arose in the year 2021. In the subsequent stages, we have annexed the GST invoice. The last payment done by the respondents were in the year 2022, May. We had wrote multiple emails and also issued a legal notice. They had failed to repay the money. So then we had registered a case in the Samvidhan portal under the MSME Act. That is in page number 35, Lordship.
what happened there?
Lordship will find it in page number 37. The status of the application is your application has not been converted to a case by MSEFC Council as of now. It will be done in due course. We had repeatedly visited the council, but they are saying that the council is not sitting. They have neither issued any notice or any action has not been taken place by the council.
Where is the application file? It's 37.
35, Lordship.
35.
An online application needs to be filed under the Act.
Where is the relevant clause in the MSME Act?
Lordship,
Resolution of disputes.
Section 18, Clause 4.
Was there any mediation initiated?
Nothing was initiated, Lordship. The complaint of the petitioner was not initiated whatsoever. No notices were issued. The petitioner was not even called for the
Have you
council.
followed up with the application
We did, Lordship. We
before this council?
Yes, we visited, Lordship. They are saying that the council is not sitting and it will be done in the due course. 1 year has already been lapsed since our filing.
So who's for the, all right, we'll issue notice, you take steps. Third council to party will issue notice, return fix steps on the respondents by respondent 1 by speed post within 1 week. Who's for respondent 2? Industries? Industry department? Mr. J.K. Goswami for respondent 2 and 3. Please obtain instructions as to why the facilitation council respondent 3 has not has not proceeded to resolve the disputes. Let this matter be relisted after the returnable date, on a date to be fixed by the registrar.
Obliged.
Extra copy. Furnish extra copies.
Dispute arises out of a license agreement. Agreement, your lordship finds at page 16. The arbitration clause is at page 15.
15.
50.
And the notice,
Notice your lordship finds at page 84. Page 87, your lordship finds the nomination.
but Mr. B.T. Decker, Leonard Counsel to the petitioner, issue notice. Return over 4 weeks. Steps on the respondent by speed post within 1 week from today. Matter be listed after the return date.
Online.
Where's the order?
Plus, the relevant portion is page 50, my lord. Para 18. Order is passed on 18 December 2005.
Heard counsel for parties issue notice, return over 4 weeks. Steps on the respondent by speed post within 1 week from today.
Representation for the reason of for releasing the area salary matter. Kindly issue the notice.
Area salary.
Area salary. Here's the posting
which-
as
which
portrait
authority?
post matter. Sir, medical
Before?
college in the year of 2008. Since 2008, he is continuing.
You are serving as what?
Sweeper. Sweeper in.
Sweeper.
Yes.
Where is your counterpart? Standing council health.
Lordship, I am appearing.
Get instructions why
Yes.
this salary has not been released.
Yes, Lordship,
Yes.
I heard Mr.
That's wrong.
S. Rahman, counsel for the petitioner, and Mr. H. Aliha,
I am appearing for all the respondents.
appearing for all the respondents. The petitioner is aggrieved by the non-release of salary,
Area salary.
area salary, towards the service rendered by the petitioner as a sweeper in grade 4 at the Silchar Medical College. Silchar. Then standing counsel will take required instructions in the matter. Although notices are not issued, the extra copies will be furnished within 3 working days. Release this matter after the returnable date. On 17th July.
Lordship.
Directed to take inspection, communicated to the department that notice inspection in the district.
Seek inspection, Lordship.
Oh,
As per our instruction, we have sent the communication for budget to the revenue department and all the proposals had already sent. 2010 and 12.
That year 2012. There are documentation.
third Mr. J.C. Bora, Learning Council petitioner, Mr. S. Doctor, appearing for the revenue department, and as for the
5 and 6.
states. Respondent 5 and 6. Issue notice returned to. Since the respondent are represented by the respective council, this is a waive, extra copies be furnished within a period of 1 week. Okay. Is there any counsel for accountant general? In the Mr. R. Boro, appears for the accountant general. Relist after the returnable date.
No, the pendency shall not be barred.
Pendency of the writ petition shall not be a bar. Ameliorate the grievances of the writ petition. Yes.
They are paying for the benefit of open that judgment. That judgment.
That's not dismissed by now. Upendas is on. You are what? Master road workers.
Master.
Where is that judgment? By which Upendas was set aside? You go through the judgment and come back. Counsel for the petitioner prays that the matter be listed next week, enabling him to apprise the court about the judgment rendered by the apex court, in which the judgment of the division bench of this court rendered in Upendas was set aside. Release the matter again on 12th. Mr. M.S. Sharma for health. 3, Mr. Chaliha for finance, and Mr.
Bisim Chari.
Zari for the BTC. Yes.
Challenges made to the penalty. Final penalty was imposed, but no inquiry was conducted. In terms of Rule 16 of the CCA rules, no inquiry is contemplated. But if the delinquent employee refutes the allegations made in the memorandum of charges, then as per the law lead dominance on the Supreme Court in OP Bharadwaj, a formal inquiry has to be conducted. That was not done. They simply issued the so-called memorandum of charges. I filed a reply and they then issued the penalty. So at this stage,
What is the punishment imposed?
Reduction in pay for 1 year.
Heard, Mr. D.
Lordship,
Bora.
yes, filed a review without an appeal. Let that be disposed of, that is pending in Chip.
Cannot be there because in terms of Rule 23 of the CCA rules, if the penalty is imposed in the name of the president, there can be no appeal. Rule
Review,
23.
yes, file review. Let the review be disposed.
Review had filed 1 year back.
In any case, Lordship, none of the respondent are within the jurisdiction of this honorable court.
Yes.
No, where petitioner?
Here.
No, where?
Proceeding was held at Lordship Jamshedpur.
No, not Johnson.
Cause of action arise at
He went on deputation to NHA. Everything happened there. The incident happened in
Jamshedpur.
Chhattisgarh. Yes, Chhattisgarh.
Then how this court will have jurisdiction?
Lordship, he is undergoing penalty right now because he is posted here.
It's posted here, but with regard to the charges, nothing. Is any
Proceeding held
cause of
at
action, had any cause of action arisen here?
Because parent department conducted it.
Which is the parent department?
Border of
Where is it headquartered?
It was served while he was posted at Himang.
Posted in Himang.
Himang is in
Then-
Leh.
Thereafter, he was transferred to Gauhati. Now he cannot go there.
Transferred in only March.
Penalty order was served where?
Leh.
In Leh. So the thing is, now
You
he's
show cause
posted in
notice served where?
Leh.
Leh.
Reply,
Leh.
Everywhere, everything happened in Leh. Just that now he is undergoing the penalty period here. That's why partial cause of action on that basis. That penalty order will be completed now in the month of June.
you come up with the law so that satisfy the rigors of the requirement regarding territorial jurisdiction. So far as this court is concerned.
Because here he is undergoing the penalty period here.
Does it make it a cause of action?
Lordship, this
Does it?
penalty arises from that.
Satisfy the court by proper judgments.
Lordship, I'll try.
You come back again with your judgments. When do you want it?
Next week,
Next week. When?
Friday.
12th. At the request of the council. Mr. Each of state for the union. Mr. Arboro. Already.
NHIDC.
NHA? NHA.
Request number 4.
Met peace
Yes.
lot.
Yes.
Milord, the petitioner here was engaged as a block accounts manager. Lordship will see he was selected on contractual basis. He was appointed at page 21. Lordship will find he was selected and directed to report to the District Health Society NC Hills on terms and conditions on contractual agreement engagement as block accounts manager in that hospital there. Accordingly, he joined, he went there, he joined, and thereafter he was transferred. Transferred to, it was into 2008, my lord, 16/9/2008, he joined. Then kindly see the transfer order at page 26. He was transferred from that Dima Hasao, BPH serial number 6. Serial number 6, and he was posted to Dorong, BPHC, district headquarters Dorong, Mongoldoi Civil Hospital. And there he was working there. It was in 2019, he was transferred, he was working there. Then suddenly there were certain allegations against officers and he was made scapegoat. He was arrested. An FIR was lodged on 27th May 2024 at page 28. Lordship will find the FIR. My name is not there. There were allegations that some irregularities, malpractice.
But you were arrested.
I was arrested. I was detained. Subsequently, I was enlarged on bail. And thereafter, I went for joining my service. And then they served this order at page 42. This has not been served to me, but I obtained it. At 42, my lord, should I read it out? Whereas it has been informed by the Joint Director of Health Services, come Member Secretary, District so-and-so, Darong, District, VD letter number so-and-so, dated 3/6/2024, that Sri Bhoben Deka, Block Accounts Manager, NHM, Mongoldoi Civil Hospital, was arrested in connection with Mongoldoi PS case number 147 of 2024 under section 406, 408, 409, 420 IPs relating to irregularities and misappropriation of government fund. Whereas Sri Bhoben Deka was forwarded to the Honorable CJM, Mongoldoi, and since 31/5/2024, Mongoldoi PS has been detaining Sri Bhoben Deka into district jail, Mongoldoi. Considering the ongoing police case and his detention in jail, Mr. Bhoben Deka, Block Accounts Manager, NHM, Mongoldoi Civil Hospital, Dorong, is hereby barred from serving until further order with effect from the date of his arrest. It is a kind of suspension. They have barred me from.
What kind of an order is this?
Yes. How can they do this? They can
You are
suspend me.
virtually terminating him.
Yes. I put a representation. Next page. Page 44. They allow me to join.
Yes.
But they have not done anything. I am being deprived of my livelihood. My right has been all flouted without any procedure.
Yes, what instructions NHM is appearing here? NHM.
NHM.
NHM,
Should I allow me some time to instruction or not?
take your instructions, but this appears to be in effect a termination order. You're not allowing him to join because he was arrested. No proceeding, nothing.
Even criminal case is also not done, no charge sheet filed, nothing. I have been made scapegoat because there are big
Get it
pieces are involved.
by 15th. Get your instructions by 15th. We'll have it on 15th, Mr. Monto.
Yes, yes, yes.
Heard, Mr. KK Monto. But you are half visible through the camera. Any particular reason? Heard, Mr. KK Monto, learned counsel to the senior counsel to the petitioner, assisted by. Yes, now we can see you.
Yes, I am good.
Assisted by so and so, MS so and so, and MS Edas appearing for NHM. Respondents 2 and 3. MS S Sharma for respondent number 1, 4, and 5. So 4. Huh? District Commissioner S Barua for respondent number 4. Petitioner was working as a block accounts manager in Mongoldo Civil Hospital under the NHM. On contractual service, he had completed 15 years of service. Stopped in pursuance to an FIR lodged by the complainant. Petitioner was arrested. Subsequently, he was released on bail, and thereafter by order dated, impugned order dated 18/7/24.
24.
From 24, you have not been allowed to
No,
join.
nothing. Well, I'm going, they said, wait.
Petitioner was not allowed to join, was barred from service until further order with effect from the date of his arrest. He submitted that no proceedings are initiated. No show cause notice has been issued. There is no charge sheet filed in the criminal matter regarding. And
No
for
charge
which
sheet filed.
the respondent authority has issued the impugned order, debarring him from service until further orders stop being agreed to. He has filed a representation dated 17/9/24, which has also been kept pending. Stop being agreed, the present writ petition is filed. Considering the submissions made at this stage, without issuing notice, the court permits the standing counsel NHM to obtain her instructions as to why the impugned order dated so and so was passed. Let these instructions be placed before the court on 15th of June. This is not issued, extra copies be furnished. Can you serve it within the course of the day?
Yes.
Extra copies be furnished within the course of the day to the respective standing councils. Release this matter on 15th of June.
June. Oblige.
My lord, the petitioner is Constable Carpenter's presently posted in 10 Battalion Serbia, Howley Manor. Here the prayer of the petitioner is petitioner wants to replace the name of his nominee with the name of his father, my lord. The petitioner has filed an application on 29/2/2004. You will find on page 22, Annexure 4. It's a translated type copy. The petitioner filed an application for change of nomination. Here but however, no response has been met from the department.
What is the stage of the criminal matter?
My lord, it's the 15th stage, my lord. And then as per the Mohammedan law, my lord, I have divorce has been granted to me. Your lordship will find on page 19, my lord, next to 2.
and my ex-wife is a prime accused in the particular criminal.
All right, let us issue notice, heard learned counsel for the petitioner. Issue notice returnable. But you have to array your ex-wife or some authority. How do we know what is the status? Why have you not arrayed her as a party? That you have to array her. Her name was there as a nominee.
Yes, my
You
lord.
are seeking her deletion of her name.
My lord.
So without arraying her, you'll have to array her. Then you file an application, then we'll issue notice. Petitioner before this court is presently serving as under the CRPF,
My lord, CRPF.
posted at
10 battalion, CRPF Howley, Kolkata.
10 Battalion CRPF Howdy. Stop. Petitioner's grievance is that his former wife was the nominee in his service book. He is accused of the heinous crime of killing the mother of the petitioner, and criminal proceedings are underway. Therefore, he had filed an application before the authorities praying for deletion of her name and instead put the name of his father, namely so and so. So, the representation filed before the authorities have not been disposed of, and the petitioner therefore is aggrieved and has filed his writ petition. Stop. It appears to the court that the only grievance of the petitioner is seeking a deletion of the name of the nominee reflected in the service book of the writ petitioner, who happens to be the former wife of the petitioner, as it is stated that the petitioner has already obtained divorce from the Muslim, divorced by the Muslim marriage register in Qazi of Tarabari, Borpeta, by certificate dated 11/2/2024. So under such circumstances, the court is of the view that the former wife should have been arrayed as a party respondent, as her name is sought to be deleted from the nominee, nominee as a nominee in the service book of the writ petitioner. Stop. Petitioner will take steps to implead implead the former wife by filing proper application before the court. Release the matter next week, 15th.
Okay.
MS so and so appears for
RDB. RDB.
RDB.
Made to your lord. And these petitioners, my lord, who are health workers, my lord, pertains to, my lord, they are from Tinsukia, Sipsagar, Dhubri, and South Salem.
Yes.
Now, my lord, they were initially appointed by the Hospital Management Society. Now, my lord, they were naturally they would like for their, giving some prominence to their job and all. Therefore, there were 2-3 petitions filed before this honorable court, Lord, when this honorable court gave direction for consideration of their case. Now, my lord, apparently, Upendas's case in the division bench judgment is something which is in the mind of the state, my lord, ameliorate the condition of this health workers. To that effect, if your lordship should kindly come to page 131, a communication has been issued by the director to all the joint directors.
Yes.
Now, as per the meeting held in the chamber of respected Dr. Pranoti Gugoi, Additional Secretary to the Government of Assam, it was clearly instructed that the requisite supporting document in respect of the concerned employees, which are to be submitted based on which the first list of employee was prepared and submitted on 7/26 by letter dated so and so. This said list contains 57 employees engaged during 3
pre-FRBM period and 48 employees engaged during post-FRBM period. However, it has been observed that requisite supporting documents in respect of several employees have not yet been received from the district, which are essential for verification and preparation of the second and final consolidated list. In view of the above, all district director of health services are hereby requested to submit the pending documents in respect of the remaining employees working under their jurisdiction, health institution, which within a period of 5 days from the date of issuance of this list. So and so that second and final list may be processed immediately accordingly. The joint director will be requested to submit the following documents, etc. Now it appears, my lord, they are contemplating to confine this process of giving the benefit as was given in Upendas to these 57 and 48 employees. On what basis this figure has been arrived at, we don't know, my lord. Earlier, my lord, pursuant to director's own order, our names were forwarded. For example, my lord, by my lord, letter dated 103, the director called for, my lord, information regarding the health workers working under all the joint directors. That pursuant to that, our names were forwarded, my lord, by the 133, page 133. It was sent, and our names appear in the list. Now, all of a sudden, my lord, this exercise is sought to be confined to some 57 and 48. So we, my lord, comprehend, my lord, that maybe our names have been not considered or something.
What is the meaning of 57 and 48?
I don't know, my lord. They in that communication of 131, my lord, kindly see, the director is referring to only 131. Sorry, 57 and 48 at page 131. The said list contains 57 employees engaged during pre-FRBM period and 48 employees engaged during the post-pre-FRBM. Maybe that was one of the first lists.
You are not included there.
In this, no, because our list is not considered. Our list is at page 133. 133, my lord.
In this 131,
Yes.
which list was sent?
Maybe, my lord, there are so many joint directors. Every district has a joint director, my lord. So the joint directors were asked by that 104 communication of the directorate to send all the names. My only humble submission is, my lord, cases of health workers who are similarly situated, their cases should be considered. What would be the outcome, we don't know. And at least our case should not be, my lord, kept out of the consideration process. That is how we are before lordships. That's our, at this stage, lordships will, only thing is, there is a deadline of 10. They say by 10, that lordships will get 141, communication at 141 minutes. They're trying to confine it to 10:6. Now, this is again a communication from the director to all joint directors with reference to the communication received from government and in continuation to this director's letter dated 13/3, which I read at 131. This is a gentle reminder to all districts to furnish the list of incumbents under consideration for granting minimum pay to the master role, casual, etc. In this regard, you are required to kindly submit the names, details of such employees along with the so-and-so on or before 10th. Apparently, my lord, our names are in the office of the director. So at least, my lord, we should not be kept out of the decision-making process. Page 133 list, my lord.
What is the basis of the apprehension?
The basis of the apprehension is at 131. They say this will be the only last consideration. Page 131. And similar order has been passed by this honorable court, my lord. Let them verify and proceed. Kindly see here, my lord. However, it has been observed that the requisite supporting documents in respect of several employees have not yet been received from many districts, which are essentially for verification and preparation of the second and the final consolidated list. At least, my lord, the authorities have
You are
not...
apprehending that your names will not be included in the second and final list.
Yes.
But this can only happen if the particulars are not forwarded.
Yes.
From the joint director's office.
No, my lord, because they are referring to only 57 employees in the pre-FRBM period. We pertain to the pre-AFRBM period. They say they have received the list of only 57 employees in the first paragraph. That is
According to you, how many employees should be there?
Should be more, Milord.
Yes, Mr. Goel.
Page 131. Third paragraph. In view of the above, all Joint Director of Health Services are requested to submit the pending documents in respect of the remaining employees working under their jurisdiction health institution within a period of 5 days. Lordship will see, my lord, it's not limited to this 57 or 48, whatever is mentioned in the first paragraph. It says about remaining one. And on top of that, my lord, may I inform this honorable court that my lord, Upendas has been interfered with by the honorable Supreme Court on 21/5/2026.
No, this remaining,
Yes.
is it relatable to 57?
Cannot be,
Or
my lord.
beyond
That's why I
57?
says remaining ones.
No, you have to read para 3 with all.
Yes.
First para says 57.
No, first of all, my lord, this document cannot be said that, my lord, it is connected to only those 57. So
That is
from
why
nowhere
it is
one
the
document,
apprehension.
yes, apprehension. From nowhere it has been, my lord, annexed, my lord. What was the purpose of the meeting? What was there, my lord? Remaining
One way
working under
to understand this document is 57 employees. Out of these 57, some requisite documents have not been received. So therefore, for those remaining employees, these documents should be furnished. So
remaining
everything
means within the 57.
within the 50. Or does it mean the 57 is all right? There are
In
others
addition to
against
that
which it
other-
is not received. That's the only clarification you give us.
Yeah, you know. But my
Yeah,
lord,
or
Upendas is not there, my lord. So far as the benefit of Upendas is concerned, whether that can now be granted on 21/5/2026. It has
You
been
examine the judgment and say what is there, but if Pendas is not there, the earlier
Let us-
judgment on the basis of which
let us be very clear about one thing. When there's no law was laid down, state came forward with the proposal, which was accepted by the. So that was the state is always in its right.
That is an argument. That is the benefit of being on the other side, that you can say no law is laid down, but it's not open for us to say so. So therefore,
Milord,
as
there is
far as
already a similar order passed at page 169.
No, let
by
me
coordinate
correct
bench.
169.
Coordinate bench, Milord.
Yes, my lord, we have filed that.
Now, if your lordship should kindly come to paragraph 6, 170. After going through the judgment and order, I find that it is also a case where similarly situated employees engaged by hospital
Which
management
judgment?
committee has approached this court.
Which judgment is referred to?
That judgment is
Some other judgment.
yes. I say annexed. We have annexed it now. At page number 143. Yes.
So let the instructions come.
Yes.
If he says that it includes all others
Our
similarly
consideration.
situated.
Yes. Only thing is, Milord, since 10th is the deadline, could it be on 9th?
9th?
One day it will be difficult. But the deadline, my lord, day before this honorable court, my lord. Always this honorable court can
No,
revert.
Milord, let my learned friend try, Milord, in
Let it
case
be
he
on-
doesn't get.
Let it be on 10th only.
10.
Or on 10th.
10th? Right. Release this matter on 10th. On which date, Mr. the additional lady will obtain instruction regard to the intent of the communication dated 13/3/2026. So the petitioners, Mr. K. N. Chaudhary, Senior Counsel, assisted by Mr. R. Dekar, for the petitioner submit that the government is initiating a process for giving the benefits health workers like the petitioners. However, the communication dated 13/3/2026, bracket annexure D, raises an apprehension in the mind of the petitioners that their cases may not have been considered, may not be considered. Under such circumstances, the instructions sought for be placed. Released on 10th.
10th.
Although notices are not issued, extra copies be furnished to the standing council. Can you do it during the course of the
Yes,
day?
yes.
Soft copies you can give.
Soft copy will be more convenient.
Soft, hard, whatever you want. Within the course of the day.
So the petitioner before he was appointed as a constable in the Assam Rifle, my lord. But subsequently he was his appointment was cancelled. My lord, may come to page 64. Annexure 10. Here is, my lord. That cancellation of appointment letter refer to provisional appointment letter number so and so dated so and so. It is intimated as per above mentioned letter, you were provisionally selected candidate for the post of recruitment ZD Pro SSC Rally 2024 and reported to Assam Rifle Training Center and School on 24 February 2025 for basic military training. As per policy in vogue, primary medical examination was carried out before commencement of basic military training. While carrying out primary medical examination by medical officer, you were found with medical anomalies, distant vision within bracket right 6/36 and left 6/6, and case was referred to HQDGAR for necessary directions. Board of Medical Office was convened at ARMH, Lightcore, and you have been found unfit for training of Assam Rifle Service due to defective distant vision right eye. Number 4 is HQDGAR has directed that you are unfit for training Assam Rifle Service by letter number so dated 9 June 2025. Hence, you were your candidature is hereby
During
cancelled.
the selection process, was there no medical?
Yes,
training?
sir, that is what
That
I
time
would
it is
refer.
after at that time of training, again medical test was
No,
done
madam.
on that day.
Lordship may come to page 57, my lord. Page 57. This is the medical report, my lord. Page 57 is regarding X-ray. This is annexure 7, my lord.
Yes.
X-ray.
But your eyes and everything were not.
Yes, my lord, lordship may come to finally page 59. It is the last page of the medical report. Here, my lord, lordship may come to bottom part, that is at serial number 27. Finding of medical officer. There were two options: fit, number 1 fit, number 2 unfit. Then they declared me as fit. It is written as fit, my lord. Page 59. Now, my lord, another relevant part is at page 61, my lord.
What is this, page 58?
58 is the medical report, part of the medical report, my lord.
So I can see it appears to be superimposed by some other document.
Yeah, my lord.
One part reflects to your blood
Yes, my lord. Blood
report,
It was blood report.
and the other is perhaps something to do with your eyes, where part of the report is visible, 11, 12 and all that.
My lord, the submitted that we have collected anyhow, my lord. But finally, my lord, at the page 59, my lord, they have declared me as fit.
No, I want to see, was any evaluation undertaken for your eyes? Was it done or not?
As per our instruction, my lord, it was done. And
then where is that report?
Yes, my lord. Of course, it will be according to them. But my lord, my humble submission is that another relevant part, that is my lordship may come to page 61, my lord. Page 61, annexure 9. Then the relevant portion is at my lord, page 63. It is at serial number 10. Page 63, my lord, serial number 10. The validity of medical examination is 1 year from the date of detailed medical examination review medical examination as applicable.
So every year there will be a medical examination.
No, my lord, it is not that.
Then?
According to them, my lord, individuals joining after 1 year of their detailed medical examination review medical examination during the recruitment process will have to undergo medical examination again and qualify it before joining the basic military training. This is regarding the who joins after 1. My lord, normally it supposes that, my lord, medical report, it is valid for a year. And my medical examination, it was on 30/10/2024, my lord. The page 57 is clear, my lord. The medical report, it was on 30/10/2024. So accordingly, it was valid for at least 29/10/2025. But this, my lord, impugned order, it reflects that It was issued on 20th June 2025. So, my lord, two questions are here, my lord. One is that how they have examined the petitioner again medically, and if that is done under what circumstances, my lord. Nothing is reflected in the
Yes.
MPN program. And then he has not even been any salary, my lord, during the training period. Yes, he was there in, for a period of 4 months, my lord.
Where is the cancellation order?
It is, my lord, page 64. my lord.
Yes, madam.
Such an instruction will be required.
For parties issue notice. Petitioner is aggrieved by the impugned cancellation of appointment letter communicated to him by communication dated 006/2025. Stop petitioner was inducted into the Assam Rifles as a constable GD.
Yes.
Pursuant to the recruitment and the recruitment and selection process taken. It is the submission of the counsel petitioner that during medical examination prior to appointment, he was found to be medically fit, therefore was inducted in service of some rifles. However, thereafter medical examination was again undertaken during the basic training, and he was found to be unfit because of distant vision on his right eye, and was therefore medically invalidated out of service by the impugned order dated 2006/2025. MSS Orwell and CGC is for the respondents. Issue notice, return of steps on the respondents by registered post. You are appearing for all, huh?
All.
Since he accepts notice on behalf of all, notices are waived, extra copies will be furnished within a period of 1 week. Matter be listed after the return of date.
My lord, can he be permitted to complete his training, my lord?
You terminated 1 year back.
And just praying, my lord.
No, you're praying, but don't make prayers which are not capable of being granted. You are coming after 1 year of
My lord,
termination.
that's right, my lord. But it is as per medical, one under the medical examination that was done by some.
So we'll examine on that, the return of
Yes.
date.
So this is the second round of litigation. Petitioner is a audits inspector under Cooperation Department. The impugned transfer order is at page 26. Petitioner is at my lord serial 18. Was my lord transferred from Kamrup Gauhati to Borpeta, my lord. Thereafter, this was my lord done during the election process, my lord. Thereafter, the petitioner approached this honorable court before your lordship, and your lordship's order starts at my lord page 39. And relevant part, my lord, operative part is at page 42. For that, my lord, page 46 is, my lord, the ground for challenging, my lord. The petitioner, my lord, has a son who suffers from autism and has benchmark disabilities. His disability IDs have been, my lord, annexed the petition. The lordship had directed then the election commissioner to consider the case, and with a direction for no coercive action. Thereafter, my lord, from the election commission, my lord, there was no reason order, and on top of that, my lord, her salary has also been stopped. And my lord, there is a judgment of this
Let us
honorable
issue
court.
notice, let him get instructions. Third. G. Bodoloi, is accepts notice on behalf of this
1, 4, 5, 6, and 7.
1, 4, 5, 6, and 7. And A Chakraborty for respondent number. When notices on behalf of respondent 1 to 7 are waived, extra copy will be furnished within a period of 3 working days. Steps on respondent 8 by registered post within 3 working days.
Madam, some interim protection, madam.
What interim?
This order should not be acted upon, madam.
Which
This,
order?
transfer order, who are the petitioner, madam?
But it was valid till 31st of March.
Lordship, I have an instruction. Says that we have forwarded her representation along with other documents to the election commission, and the election commission has directed us to put her on a cell duty during the time of election, Your Lordship. On a cell duty, Your Lordship.
What
Cell
duty?
duty or a duty of DCRC, Your Lordship.
But that is, my lord,
That-
not with regard to Gauhati, my lord. And we have specifically argued that her.
So your order at para number 13, the interim order is in operation till 31st
31st of
March for disposal. So assuming your representation was not disposed, representation not disposed.
Not disposed.
Submitted by the council that earlier the petitioner had approached this court by filing writ petition being a challenge to the transfer order. This court by order dated 18/3/2026 in WPC 165 of 26 disposed of the writ petition with the following direction. There are 9 over 13 step. Submitted by the council to the petitioner that the representation filed by the petitioner was never disposed of and order was served. Therefore, in terms of the order dated 23/3/2026, the interim order was to continue till 31st March or till the disposal of the representation. So, but it is still 31st March. Can't extend it.
That is for, my lord, this fresh petition, because the conditions are peculiar, my lord. This child, my lord, needs constant attention, and petitioner needs to be stationed at a place, my lord, where she can immediately attend to.
Where are you transferred?
Borpeta, my lord.
From?
Gauhati, my lord. And my lord, Rights of Disabilities Act also.
However, since the petitioner submits that she is the sole caregiver, physically, autistically challenged,
Yes.
autistically,
Mentally challenged.
intellectually challenged child, her transfer property to Beta will not be in the interest of the special child and in violation of the provision of the Rights of Persons with Disabilities Act. So and so till stop. Therefore, the next returnable date is transfer dated dated
15/3, your lord.
15/3. So far as the writ petitioner is concerned, will not be given effect. Released again on 17th July.
Obliged.
Background litigation, my lord. Initially, the petitioner was enrolled in the Assam Rifles as Constable GD, my lord, in the year 2001, my lord. Thereafter, his service was terminated on medical ground. Then he approached this honorable court, and this honorable court will direct the respondent to on medical. That was done in the year 2012. Again, he was, my lord, declared medically unfit. Subsequently, he filed another petition That is your lordship will find page 26. Party portion is 9. Direction to the respondent. Page 29, my lord. Then bring the position for you by a medical board. By directing the response. This ethics medical board. Kindly see the medical board proceeding. It's 30 minutes. Third, 3 doctors were inducted in the medical board, my lord. One is my lord, medical specialist, another one is pulmonologist, and another one is pediatric. That unfit is 31.
Why have you included a pediatrician? Anyway,
Is 31 condition. Tremor of both hands, hypertension, and defective near vision, both eyes. A doctor of pediatric and my lord pulmonologist has no role. And they have only obtained my lord opinion from the GMCS, neurology department. That was also from OPD department. It was not my lord educated by my lord profession.
there is no direction of the court earlier to include the specialists.
But that is automatic, my lord. But board is my lord still constitutional. So there is a proper review, my lord, requirement.
Have you undertaken any examination for a civilian hospital?
At 2, my lord. Regarding I, my lord. This one, my lord, 6 by 6, 6 by 6. I think my record, then I the records, my lord. How do my lord?
Why should we examine the records? We are not doctors. We are not specialists.
How they deals, my lord?
How they have dealt it, how are we concerned? How do we verify that this system or that system is necessary? You tell us that under the rules, you tell us under the rules that it is laid down that these kind of specialists are necessary. Show us from the rules.
One is not a but
So our understanding of the manner in which it is to be undertaken is not. Our understanding of this process may not be correct. You have to show us the parameters, central government rules, health department rules, whatever they are saying, how it is to be undertaken. Why should we call for the records and examine? What are we supposed to do? We are not medical doctors.
Pediatric doctor, madam, pulmonologist. Pediatric doctor and pulmonologist, madam. We have nothing to do with
Yes, who's for the respondent?
My lord, I am appearing, my lord.
Yes.
We have received the instruction, my lord. This is for the third time that, my lord, the medical review of the petitioner.
But why are
has
you
been-
including a pediatrician? What is the pediatrician supposed to do? You might as well include only MBBS doctors.
My lord.
He's a man, how old are you?
My lord, since
45 plus.
45 years old, you are getting him examined by a pediatrician. Why?
that I will take instruction, my lord, in that case, my lord.
Please get your instructions.
My lord.
Third counsel for parties, Mr. A. Gupta, learned CVC will obtain instruction with regard to the manner and the composition of the medical board which had examined the petitioner and found him unfit. So, get these instructions, be placed before the court. 15 July,
My lord.
Published.
notices are not issued, extra copies be furnished within a period of 1 week.
My lord, this matter, this is compassionate appointment. Petitioner's case was rejected by the SLC on 7/4/2026, page 63, my lord.
Page
Page 63.
53,
63.
63.
Relevant portion 63, it starts from 60. Relevant portion means that according to them, it cannot be considered due to lapse of 9 years. My lord, in fact, my lord, the petitioner has applied, petitioner's father died on 9/1/2026 and the petitioner applied on 7/3/2026, within time, my lord. And subsequently, my lord, his case was recommended by the DLC. Kindly turn to page 32, my lord. DLC recommended the petitioner against a specific post, my lord. Page 32. Srimati Saptami Turi, daughter of Sohanlal Turi, is recommended for the post of grade 4. After that also she pursued her matter, my lord, he pursued her matter diligently, my lord, till the end, my lord. And it is only due to the lapses on the part of the respondent authorities, my lord. There was, my lord, it took 9 years, my lord. And here, my
This page 32 is recommendation of
DLC.
DLC.
Yes, my lord.
When was it done?
On, my lord,
July 17.
24/5/2017. So thereafter, my lord, there were several communications, correspondences in the department, my lord, and petitioner also pursued her matter, my lord. But
Then
my
where
lord,
is the SLC?
SLC has rejected.
Where is that rejection order?
Rejection order is at page 62 and 63.
There is a ground for rejection.
Ground for that is the lapses, there is a lapse
9
of 9 years, my lord. In fact, my lord, they have rejected on the ground of Debabrata Tiwari's case, my lord. But Debabrata Tiwari's case is of 2023, my lord. It is no longer in force, my lord. There is the recent, my lord, guidelines have been laid down by the Honorable Apex Court on 2/11/2025, my lord, in case of Canara Bank, my lord, which I have, my lord, annexed, my lord, as Annexure S, my lord. Please turn to page 79, my lord. 79. Judicial precedents on the issue of compassionate appointment. Relevant portion in, my lord, relevant portion, my lord, which is applicable in the instant case is paragraph 27 at page 83, my lord. At the bottom, my lord, I am reading. Lapse of time could, however, be a major factor for denying compassionate appointment where the claim is lodged belatedly. A presumption is legitimately drawn in case of claims lodged belatedly that the family of the deceased incapacitated employee is not in immediate need of financial assistance. However, what would be a reasonable time would largely depend on the policy scheme for compassionate appointment under consideration. If any time limit has been prescribed for making an application and the claimant applies within such period, lapse of time cannot be assigned as a ground for rejection. So here the claimant has applied very much in time, my lord. So it cannot be a ground for rejection as per the latest ruling.
Which clause you are referring to?
to page 83, my lord, para 27.
Yes.
My humble petition, humble prayer is that, my lord, you say, in order may be set aside, my lord, and my lord, petitioner's case may be reconsidered, my lord, on the basis of the latest guidelines of this honorable.
If here in this case, this Kannada Bank case, labor groups of Tiwari is not discussed, not considered. Page number 87 can be seen. Page number 87, paragraph 47 of that judgment. It refers to the larger bench rules. It was not conclusive judgment. Paragraph 47, page 87 of the repetition. Wherein page number 16 is there, lordship, of the Kannada Bank judgment, which is referred by my learned lordship. In paragraph 47, lordship. At the same time, we cannot be paragraph 47.
This is in case of Kannada Bank, my lord, not regarding the precedents, my lord.
Returnable. 4 weeks. Mr. J.K. Goswami, senior, additional senior government advocate.
Appearing lordship on behalf of 1, 2, and
Respondents?
no, lordship.
I'm 3, 5, 6, and 9.
Respondent number 1, 2,
1, 2, and 4 and 8, lordship.
1, 2,
4 and 8.
8.
Yes.
Mr. J. Andik appears for
5,
3, 5,
6, and 9.
6, and 9. Since the respondents, the representatives, the extra copy will be furnished within a period of 1 week. It's after returnable date.
So before we will see for non-payment of the minimum pay scale. Yeah, I am saying in terms of the judgment.
You are referring to Jagjit Singh
Yes.
after setting aside of Pendas.
Pendas has been.
Yes.
But judge maybe please to issue notice, my lord, we need to find our affidavit because now the parameters have changed, my lord.
Returnable 4 weeks. There are Dari
My lord, I appear for R3, my lord.
appears for respondent number 3 only.
Yes, my lord.
Mr. Bosumotari. Sorry, appears for respondent number. Respondent number
Respondent number 4.
4, then 5, 6,
4, 5, 6, 7, 8, 9,
7,
and
8,
10.
9, and 10. And who appears for Forest? Mr. Rai Botagu.
Yes, ma'am.
Forest. Since the respondents are represented, this is the way the extra copy will be furnished with the period. I thought you'll come and say that Pendas, notwithstanding Pendas being set aside, what has directed the benefit to be granted to master, your master role workers?
No, my lord, casual worker. Okay. For the casual work. But in the Supreme Court case, when there's some opportunity to the casual worker was after considering the
Right.
minimum.
After
So,
returnable.
knowledge.
Yes.
Paying for regularization of working with tax collector lordship under Bengola Gaon Panchayat under the Golaghat Jila Parishad interdict. So Golaghat ECB was appointed lordship prior 1/4/1993 lordship.
Notice for today. Heard Mr. Enzo Mr. A. Ghosh, PS4. The all the respondent. Is presently working in the tax collector. The Golaghat Zilla Purikul, the Behora Gaon Panchayat, the Golaghat Zilla Purikul, district of Golaghat. And his grievance is that his claims for regularization have been repressed by the department. Being agreed to present writ conditions. The respondents complete their instructions and file necessary affidavit if so advised in the meantime.
Right.
Make the lawsuit. My lord, page 18 to 24. Percentage advertisement dated to lawsuit 6/12/2024 lawsuit. The petitioner duly participated in the recruitment process in lawsuit and after completion of review lawsuit, the retainment available by lawsuit. They are appointed as liability technician grade 3 lawsuit. By the appointment letter dated 20/12/2025, that is page 25 to 29. So what happened afterwards he lawsuit? Accordingly, when he approached before the respondent number 3 you lost. That is the principal cum superintendent of medical college Tezpur you lost. She was not allowed to join you lost. The reason based on to him. So
Where is the order of appointment?
order of appointment is at place you lost.
25.
25 you lost.
25.
20 December 2025 have been appointed you lost. Place of posting Tezpur Medical College and Hospital Tezpur you lost. So after that you lost, I approached before the superintendent of Tezpur Medical College you lost. And he is not allowing. On 2 occasions I have approached you lost.
Why is it not allowed?
My lord, I have to obtain instruction.
Heard. Counsel for parties, petitioner is agreed that despite the order dated 20/12/2025, whereby the petitioner was temporarily appointed to the post of laboratory technician under grade 3 within bracket technical, the Tezpur Medical College Hospital, pursuant to a regular selection process undertaken. The petitioner was not allowed to join in his post by the superintendent.
Really, so that's number 3 you lost.
Who is the respondent 3?
Principal cum chief superintendent.
Principal cum chief superintendent of the Tezpur Medical Hospital. Respondent 3. Being agreed, the petitioner is before the court. Mr. D.P. Bora, standing counsel, health department will obtain instructions in the matter. Release this matter again on 19th of June. Stop, although notices are not issued, extra copies be furnished within 2 working days and to enable Mr. Bora to obtain the required instructions. This on 19th June.
Obliged.
The petitioner before your lawsuit, the assistant professor of medical college. In pursuant to an advertisement dated 13th of February 2026, case 19, regarding my lord recruitment of my lord various faculties, including the my lord assistant professor of radiology. The petition that 2 posts was there, my lord, as page 20, my lord.
At AIMS.
Page 20.
At AIMS.
Yes, AIMS. Page 20, 2 posts, one for OBC and one for my lord unreserved, my lord. My lord, accordingly, my
For
lord,
which subject?
radiology department.
Radiology. Okay.
And my lord, in the state advertisement, my lord, page 26, my lord, the figure number 19, my lord, the applicants already in government service, including AIMS employees, shall have to produce no objection certificate from their present employer at the time of interview or as per instruction from time to time. Accordingly, the petitioner submitted the application before the aims as well as one
He falls under OBC.
He's on the STP but he applied
Under
against the
UR,
unreserved.
unreserved.
And accordingly, on 4/3/2026, they submitted one petition to PROCEEDINGS for granting of NOC, right, at page 33, and subsequently, on page 34, the principal forwarded the said to the director of medical education Assam, on 18/3 for granting of NOC, and subsequently on page 35,
NOC not granted.
not granted. This is the issue, and
Your interview is on
8th of
Monday.
But till that it is pending without any reason.
Yes, Mr. Mohan.
I'll take the instructions, not granted.
Heard Mr. E.K. Sharma. Hearing the respondents 1, 2, and 3.
Yes,
Petitioner is presently serving as a
Assistant professor
in
radiology department.
the radiology department at Borpeta Medical College Hospital. Stop in deference to, in response to application number 13/2026, whereby advertisement would be meant for faculty posts in various departments, aims Gauhati. The petitioner being eligible to apply for the post of assistant professor in the Department of Radiology submitted his application. Stop. The advertisement, the terms and conditions in the advertisement specified that for candidates who are in service, a proper NOC must be furnished. By which clause?
19, clause 19.
19. NOC must be furnished as per clause 19 of the advertisement at the time of interview or as per instructions issued from time to time. They must also take prior permission of their employer while applying for the post. It is specified that no candidate will be allowed to appear in the interview without the NOC from the employer. So, petitioner, by his application before the authorities, authority, namely the principal cum chief superintendent of Borpeta Medical College Hospital, applied for the NOC for applying to the post of assistant professor radiology aims by communication dated 4/3/2026, which was shown to be received in the office on 18/3/2026. This was forwarded by the principal to the director of medical education on 18/3/2026, requesting for necessary information and action. Subsequently, the said application was resubmitted again on 2005/2026 by the principal cum chief superintendent, Borpeta Medical College Hospital. Said application, however, the said notification, NOC, not issued. What is that page number 41?
The list of some eligible and candidates. Here is I have been, my name is at page 45. Page 45. That the Department of Radiology, assistant professor, serial number 3. So I'm the only of my lord provisionally an eligible candidate against the unreserved.
But lordship, there is a bond lordship, which was entered on 2017 for 10 years lordship. And as per that bond, he has to give the service before that.
As per the list published by the AIMS authorities by notification dated 18/5/2026 in respect of candidates were considered eligible and obligor ineligible for the selection and interview selection process. The name of the petitioner appeared in the Department of Radiology. His name was listed at serial number 3 under the ST quota, and he was shown to be provisionally eligible as the subject to the submission of MD degree certificate and NOC from the competent authority. So, right, is the submission of the learned counsel to the petition that you have the MD degree certificate. Yes. MD degree certificate is readily available, but the NOC has not been issued for reasons best known to the respondents. And the interview is scheduled on 8th of June 2026. Where Mr. D. Upamanu, appearing for the state health department, submits. There is on date he does not have instruction, but it appears that the petitioner has already executed a deed of agreement.
Bond lordship.
Bond.
Deed of agreement dated lordship, 7th April 2017, which is for a period of 10 years. So it will end on 7th April.
The bond was executed on 7th April
2017.
2017 for a period of 10 years. And therefore, perhaps that is the reason the petitioner not being granted the NOC. So, be that as it may, since the petitioner has already applied for the NOC through the proper channel, the department has not communicated its decision by either accepting the request made or rejecting it for reasons determined. And as the petitioner has been shown to be provisionally eligible by the AIMS authority, the notification dated 18/5/2026, let this issue, the matter, returnable after 3 weeks. Mr. Upamanu appears on behalf of, here's an acceptance notice on behalf of
1, 2, and 3.
1, 2, and 3. Therefore, notices are waived, extra copies will be furnished. Rules for AIMS. CGC. Any CGC for AIMS? There is a standing council. Who is the standing council? Since respondent 4, namely the AIMS party represented, the court has requested Mr. A.K. Doctor and CGC to appear and accept notice on behalf of the AIMS. Considering the prayer of the petitioner that the interview is scheduled on 8th of June, the AIMS authority permits the petitioner to appear in the interview. Notwithstanding the NOC not being furnished by the petitioner, as the same has not yet been issued, and as the application for same is still pending before the health authorities. The results in respect of the petitioner, if selected, however, will be subject to further order. Selection of the petition. Selection, the result of the interview, respect of the writ petitioner, if selected, shall be subject to the further order. List after returnable date. Pendency of the writ petition will not be a bar for the health department. Writ address the grievances of the litigation.
Extra copy.
Extra copies be furnished.
I did.
Copy of this order. So you take it from the certified copy and file it. Remove the authority. Yes.
May it please the Lordship. This is basically a matter of simultaneous proceeding. But what happened in this matter, when the petitioner is a civil servant, my lord. The wife of the petitioner is also a civil servant. Now, when both of them were posted, especially the petitioner was posted as circle officer at Dhubri, my lord. One lady who later on became a complaint, she continuously harassed both of them. Lord, pictures of the petitioner were edited and uploaded in social media. My lord, WhatsApp messages were sent.
Initiated. Both the matters discussed above are not before the court. Permit the state council to complete his instructions in that respect and apprise the court the next day. This issue returnable 4 weeks. Till the next date fixed, the proceedings under the pursuance to the showcase notice dated so and so shall remain stable. Because this matter again 20 April, 20 June.
And
Extra copies be furnished.
what is second?
20. The July.
July.
Please furnish extra copies.
Yes, ma'am. But it's to be PS case number 424, ma'am.
PS 4,
2024.
the case filed by the complainant.
Complainant.
But in this case, my lord, there is an area dues of a retired employee. This dues, as per the today's, my lord, account statement is 1,43,991 rupees. Within 2 days, we will pay the entire, sorry, within 2 months, my lord. Lordship may record this and dispose of the amount.
Who is for the applicant? You release this amount as per your instructions.
My lord.
We release this matter after 2 months.
My lord.
And
That
then
can be done.
Release the amount, we close it.
My lord.
None appears for the petitioner on call. Standing counsel for the ASTC submits that terms of the accounts maintained by the respective by the ASTC in respect of the applicant, total of rupees 143,991 is amount required to be released. So is submitted that the same shall be released by the ASTC. Can it not be within 1 month?
I will try to do it, but outer limit I have kept.
Will be released expeditiously. Few of the submissions made, release this matter again. August 5th. It is expected that the amount standing in the name of legal heirs, it should be legal heirs.
Yes, legal
heirs of the
late Khurshid
Alam should be released without any further delay, as expeditiously as possible in the outer limit, by the next returnable date. Is accordingly.
I'm deployed.
Yes, my lord had directed my lord the petitioner to take steps on the private respondent through office of PCCR, my lord. Accordingly, my lord, I had facilitated. It has been brought on record, my lord. But now, my lord, PCCR's office, even to my surprise, is saying that those notices are, my lord, not traceable, and they are not, my lord, sure whether the notices are sent or not. So at this stage, my lord, I am praying that the official email IDs of all the private respondents, my lord, I will, my lord, ask the PCCF to share soft copies of the petition through that email. That was issued in September, 1st of September. That's so to program record the acknowledgement they have received. From our side, my lord, that is the letter which we had.
So you had taken steps,
Yes, my lord.
but there is no returnable day. I mean, there is no postal receipt available.
No receipt, my lord, and the office is also, my lord, unsure whether they had even sent those or not, my lord. Even though from our
When
side,
was the order directed to be sent? When was it directed to be sent?
somewhere last year, 15th of July, July 25.
15 July 25.
Yes, and it was lodged. We have
Then why was it not sent?
from our side, my lord, it was sent, my lord. That letter, my lord, will find in the affidavit of the petitioner. That
No, but you said it is not traceable or something like that.
from the PCC's office, my lord, they are, my lord, saying that
I don't understand. From our side means whose side?
from the council side, my lord, we had sent those notices to PCC's office as reflected in the affidavit. In
Why the PCCF has not sent it?
my lord, the office is unsure, my lord, where those notices are.
How can the office of the PCCF be unsure whether it is sent or not? They have defied the order.
Not in defiance, my lord, but I would say
The expenses are
oversight.
to be borne by the petitioner for the postal.
We have done it. Our party votes.
You have submitted.
No, my lord, expenses here, it was sent, supposed to be sent through PCCF side.
No.
Copies were supplied by petitioner, extra copies.
Extra copies.
Yes.
So why
through registry also.
why the PCCF's office is unable to say that whether it was served or not?
That is, I am also, my lord, clueless. They,
Right. They don't want to spend the money. You give the details, you give the particulars to the petitioner, he will.
Yes, I
He
will.
will bear the. Huh?
That part we have already done.
Where?
After the order passed on 15/7 also, we have initiated everything and we have submitted before the registry. And registry has also processed the dusty service. We have received the dusty service and handed over to the Council of Others. And Council of Others has also sent the documents to the PCC.
What is that order? Let us see.
15/7.
15/7.
25.
15/7.
Dusty service.
It did not say dusty service. Petitioner will take steps to the department.
To the department.
And the concerned officer department will serve copies.
That's-
There's no dusty service
But
here.
we have taken the as a dusty. We have taken
How you can take dusty? Who will go?
we have submitted was after pass.
Dusty service means what?
I can understand what is dusty service. But the
Ah.
thing is that also, after passing this order, our clerk has issued every procedure, and they have also after getting ready, we have provided the copy to the learning council. They have sent it, and after sending the copy, also they have given me an acknowledgement. I have also brought on record the acknowledgement. So this is the acknowledgement through affidavit we have brought on record. It was filed on 11th of November 25.
Yes.
So this is the also equipment receipt they have has been provided to us by the learning council.
But who will bear the expenses?
We have already paid the expenses regarding this processing. After getting from registration, we have handed over the copy
How are these notices to be sent?
through the Lordship Advocate Council of
By what medium?
medium is not mentioned in the order Lordship. That is why we have given the hard copies also today.
So how do you expect the office to undertake these steps?
This order probably
Order has not clarified, but it
but
is
we
in
have
your.
given the copy also.
You have come to the court, arraying them as parties, in order to give you the benefit of getting the addresses and serving it. We
Initially,
permitted you
Lordship.
to take steps to the department. Now you have handed over copies. How do you expect the department to send it?
Normally, department send it Lordship.
How?
How there is their Lordship mechanism. They will know how they will send.
We have given.
All right, one thing, you give the addresses to the petitioner, he
Yes,
take steps.
Last occasion also, we have.
You give the addresses
Yes, I will
to the
give.
petitioner and he will take steps.
In Lordship, already last occasion also notice was served, duly served. After justice Lordship, the Lojima court order is there.
Where is that?
So, Lordship, I'm sorry, I have not seen the official, but Lojima order is there, Lordship. Regarding service of the private transport. Long back in Lordship, probably in 2024, 24 itself, which was served. Then after Lordship, about 1 year, Lordship, this order was passed on 15/7. Accordingly, you have again steps were taken by us. And now it is 9 months has
There
gone.
is no there. Lozima order is that you are to take steps by dusting.
No, Lordship, probably it was in 2024. Notice was served, Lordship. It is served. We are not in trouble to Lordship again issuing notice, but in this there was a time is it is case of 2016 Lordship, second round of litigation. They have received the notice Lordship. But now the response of the responding side is that Lordship. They are even unaware whether it was served to the respondent or not.
Therefore, this court directed you to take steps to the department. Taking steps to the department does not mean you make copies and hand over to the department. How will it be sent?
So,
Huh?
so
That July order?
July. Prior to July, Lordship, it was notice was served.
No,
That's the second time it's prior to July 25, Lordship, it was served to the respondent. Again,
but
it was directed to serve.
in pursuance to July order,
Yes.
you have already taken steps.
Lordship.
Taken steps to the effect of handing over the copies.
Lordship.
That's all.
Then Lordship specifically direct how we have to provide, how we have to serve text test. Last order reflect that we have to copy through the department. Accordingly, we have given a copy to the department council. So now they are submitting us whether they are not sure whether it was served or not.
In deference to the earlier order dated 15/7/2025, it is submitted by the council to the petitioner that petitioner had undertaken the exercise of handing over the physical copies of the petitioner along with the notices to the office of the PCCF. For service of notice on the private respondents, stop the several opportunities were granted to the respondent. The counsel for the forest department submits that copies were handed over. It is not clear as to the department is unsure as to whether these notices were at all sent. Under such circumstances, the department may alternatively procure the present addresses of the private respondents and their places of posting, along with the emails and telephone numbers, if any, so that the copies of the writ petition can be sent through the email and of legal alternatively be served at the addresses as may be provided. The standing council will furnish the complete list, the complete and the correct list of the places of posting and the complete address, including telephone numbers and emails of the, including emails, effective emails of the private respondents to the council petitioner within a period of 2 weeks. The petitioner will thereafter ensure service of copies of the petition at the addresses of the private respondent and the addresses provided. List accordingly.
I'll text you immediately after getting the.
You take steps, you file your affidavit. Petitioner will also file an additional affidavit. Petitioner will intimate the court as to the steps taken pursuant to the particulars being handed over by the council. After 3 weeks.
All right.
Yes.
Service copy of epidemic is replied to the respondent.
Getting completed. Complete.
Pleading complete. You have filed a rejoinder.
Yes.
It is submitted that the pleadings are complete in the matter accordingly, matter issue. All the records list for hearing. The usual course. Yes.
But then, usual course in the minor time.
It will take time. It has to be heard.
My lord, here in this case, I have filed an amendment application for praying for amendment of the writ petition, my lord, on the ground that initially I have challenged the draft gradation list, my lord, but after filing of this,
Yeah, there is this IA 3403 is for implement.
it is actually amendment, my lord. Amendment.
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 Any objection from the respondent?
No, Lord.
Right, Mr. S.K. Ghosh, I is an application filed for praying for amendment of the writ petition. You are filing combined application for amendment and implement.
Because initially the draft gradation list was challenged. Now, finally it has come out. So when we have challenged the final gradation list, automatically one private respondents come out above us, my lord. So I have to implement.
That's what we are asking you.
Yes.
You are filing a combined application.
Combined.
Can it be is it
Yes,
permitted?
Yes.
Then we'll have to issue notice on the
Or
private respondent.
after amendment, yes, notice will go to the respondent number, private respondent.
Since it is also an application for amendment, let notice issue. Private respondent. Notice is already issued.
My lord, in the amendment petition, notice issue. Now, after amendment is allowed, my lord, I will take steps in the main writ petition.
Have you seen the last order 18/11/24?
Not.
So 18/11, you are permitted. Court has issued notice seeking implement of the party.
Was issued by lots of implement of the party respondent notes.
This was issued, then matter was before Lozima. Lozima directed you to take fresh steps. That appears to have not been done.
But earlier we have taken steps that has not come to,
But you have to take fresh steps.
I will take fresh steps.
Counsel for the petitioner is permitted to take fresh steps in the matter after the matter be listed after 4
My lord,
weeks.
may I permitted by justice?
Whatever you want to take. As per the Lozima court order, take fresh steps. Custody is also permitted, provided you play through the office of the registry of this court. Study Chakraborty appeals for the opening partners.
So, 29.
Declaration of the successful public is that where Honorable Justice Manzar has given his consent for arbitration.
In deference to the order dated 11/5/2026, the prospective arbitrator, Justice Manojit Mia, former judge of the Gauhati High Court, has furnished a written declaration by communication dated 19/5/2026 through the registry and is placed before the court stop. The written declaration does not disclose any hurdle, any hardship or dispute, a difficulty that may arise in Justice Mia's appointment as an arbitrator. The appointment of Justice Manojit Mia as the sole arbitrator by the earlier order dated 11/5/2026 stands confirmed. Copies of this order be furnished Justice Manojit Mia, judge of the Gauhati High Court, by the registry of the office. Parties are also permitted to place copies of this order before the arbitrator appointed by this court. The parties will now appear before the arbitrator on
After 19.
26th of June. 26th of June, whereupon the arbitral tribunal constituted will proceed to invoke its jurisdiction as per provision.
We are ready to take part in the arbitration. Then we dispose.
Matter disposed of.
Thank you, please.
I for implement of parties lawsuit, opposite party number 8 and 9, Director of Pension and Accountant General. First occasion we will ask to serve copies lawsuit. Copies will serve.
Yes.
For
Any objection?
I said no objection. I'm for the BTC law. So for BTC.
Any other objection from any council? Any parties?
Here, AG is appearing.
Here for the accountant general. Any objection? You are seeking implement of the AG.
Yes, Lordship.
Director of Pension and Accountant.
Pension and accountant general. Yes, who is for the director of pension? Director of pension. Any objection? Heard council of the parties. It's an application seeking implement of director of pension in the office of the accountant general as party response. I issued on 23/3/6. So the parties are duly represented. The parties are represented by their respective counsel. There is no objection raised by counsel representing the opposite party number 8 and 9. So such circumstances, consideration of the grounds urged that the party 8 and 9 will be necessary party in deciding the issues placed before the court in the accompanying petition being WPC number so and so. Prayer made in the highest and the law. The party 8 and 9, detailed to pleading serial number, are added as party respondents 8 and 9 in accompanying writ petition number WPC number. I therefore state the law, petitioner will file amended post title within 1 week, within 2 weeks from today, the registry. And the writ petition, right, in view of the order passed in I today, I number so and so, so and so, so and so, there it is, party respondents 8 and 9. Petitioner is directed to file amended post title within 2 weeks from today. Matter be listed thereafter. What extra copies, fresh copies of the writ petition after amendment of the after steps undertaken be served. But she's not praying for amendment; he's only praying for array. Then why extra copies? Extra copies were already served.
Already served.
After the implementation, we have not issued notice on the newly implemented. Then let him get his. Let him get it. Let him file the amended post title. Thereafter, we issue. Yes.
Kindly look into the last order. Steps have been taken by. Kindly look into the last order dated. Steps have been taken by the petitioner through speed post by law.
As per Lozima Court order dated 19/5/2026, service on respondent number 6 deemed to be presumed to be served. Is respondent 6?
Private respondent Rohima Beva, my lordship.
What is your claim?
A claim, my lordship, the petitioner and the respondent number 6 is the co-wife, my lordship, and the husband of the petitioner is the died, my lordship.
You take dusty service?
My lordship, I can. Yeah, ma'am.
Since the service of since the issue between the petitioner and respondent 6 is with regard to the pensionary
Yes, my lord.
family pension, claim of family pension in respect of let Samsul Alam Sarkar is stated to be the wife, who is stated to be the husband of petitioner and respondent 6. The petitioner is permitted to take service on respondent 6 by way of dusty. An affidavit of compliance we file immediately after effecting dusty service. Just after 4 weeks.
Kindly make expected.
No, you file your affidavit after that.
Okay.
MS so and so it is the state. Mr. H.
So, can you peruse the office no para? Well, I. Sabi na yung
As per office note dated 12/5/26. Service on respondent number 3 is presumed to be complete. Represents the respondent 3. Mr. You are appearing for respondent 3?
1 and 2, Lord.
Mr. D, when you respond. Why can't you take dusty? Your claim is against respondent 3 only.
Yes, ma'am.
Well, in the absence of the respondent 3, what order will you get? Since the claim of the writ petitioner is primarily against the respondent, we permit the petitioner to undertake dusty service within 2 weeks. Affidavit of compliance to be filed thereafter. List after 4 weeks.
Alia.
Yes.
I'm the petitioner detail pro. And as per order of your lordship, 3/6/2026, steps has been taken and submitted before your lord. In file on record is black marking color.
Yes.
Lordship, so Lordship may please to consider the IA selecting another.
What is the I?
The IA is your Lordship selecting for another arbitrator.
Why? What is wrong with the arbitrator name?
Lordship, it has been consent to the petitioner. File for a modification.
Order dated 25/10/24.
Yes, sir.
Where is the order?
In main arbitration petition, your lordship.
Is the ground for modification? Is there any objection in appointing a former judge of this court?
Lordship, the financial position of the petitioner is not good. And last 6 years, the respondent has not paying a single rupee.
No, but you'll have to make payment to the arbitrator you have selected also.
Also, lordship,
You're apprehensive that a former judge will charge more money.
lordship.
So at this stage, once we have already passed the order, let the arbitration proceed. Thereafter, if you have any issues, you can come back to the court. But you see, the notice was issued to you under 21, you did not respond. They came before the court, notice was issued, no response. Now, after the order was passed, you have filed this application seeking modification. Where are the parties residing? Which part?
Lordship and Narangi, petitioner.
Both the parties.
Respondents, VIP, yes, your Lordship.
In
Narangi.
Kamrup.
Yes.
But the arbitrator is in Dibrugarh.
No, Lordship.
Huh?
At Chanmari.
January. You are Mr. A. Decca.
M. Sir.
Who's A. Decca? Represented respondent 1 and 2.
I'm on behalf of P. Monson. Your Lordship.
The order of 2510 reflects the name of Mr. A. Decca, who was the appearing for respondent 1 and 2. File to some. Second file again. Respondent. You are appearing for which respondents?
1 and 2.
1 and 2. What is your name?
M. Sharma, Your Lordship.
M. Sharma.
Yes, Your Lordship. On behalf of P. Monson.
You have not executed the wakalat. You have not signed the wakalat.
No, Your Lordship.
Please inform, there are about 4 or 6 counsel who have filed the wakalat. Where are they? Where is Mr. Monto?
He's, he was, so he just came from a leave.
He went home.
Just came from a leave. He was on leave. Taking medical rounds.
Has he joined?
I came on his behalf, Your Lordship.
No, you come on his behalf, but this is a matter where the court has recorded the presence of one Mr. A. Decca, appearing for respondent 1 and 2. Then this wakalat says that There are 6 counsel appearing on behalf of respondent. Which respondent is not clear?
5, 6, 7.
Huh?
I have 4, 5, 6, 7.
You are for 5, 6, 7.
It's related. Main petition. My son. Petition.
Your vocabulary is there.
Yes. 5, 6, 7. Ardas.
But for 1 and 2, not clear. Were respondents 5, 6, and 7?
Myself. Ardas.
I know, but what is their role in the arbitration? They are partners.
Actually, we are. I am the landlord. My father was the original landlord, and the main petitioner is my son. So from me, I have issued power of attorney. But till now, we have got no red. There was a partnership between the petitioner and the respondent.
Respondent 1 and 2.
80% he was supposed to get. Okay. But till now, nothing. For 6 years, got nothing. No. Quite the-
Third, counsel for parties is IA. IA can file seeking modification of the order dated 25/10/24 passed by this court in arbitration petition 6 of 2024. Petitioner is seeking modification and with a prayer for appointment of a retired judge of the Honorable High Court of the District Court to adjudicate the matter. The ground urged before the court is that the arbitrator was chosen unilaterally by one of the parties and therefore has expressed doubts regarding impartiality and independence of the proposed arbitrator. Stop. The order dated 25/10/2024 was passed in the presence of the council. Stop. The agreement executed by and between the parties, between petitioner and respondent 1 and 2, had contained arbitration clause and which is not disputed. It is under section 1 was issued, which was also not replied to by the respondent 1 and 2. Under such circumstances, when the petition is filed and notices are issued in the IA, the claim of the respondent for appointment of an arbitrator, the liberty of the respondent for appointment of an arbitrator is lost, as has been held in Tata Switch Gear, also reported in Switch. Such circumstances, the court by the order dated 25/10/2020 had appointed the arbitrator. so and so. Stop. The arbitrator appointed the arbitrator so and so, who's the arbitrator chosen by the petitioner, and it is dated so and so issued by the petitioner. So, said arbitrator had also given his written declaration under section 12.1, expressing no difficulty in issue. So, meanwhile, after issuance of the order dated 25/10/2024, the petition was listed on several dates, which date submissions were made by the parties before the court that an attempt was made to resolve the matter by mutual settlement. So, however, till date, the court has not been informed of any such settlement between the parties. So, such circumstances, this court is disinclined to allow the prayer made in the IA, so and so. IA accordingly stands dismissed. The arbitration petition is right in view of the declaration submitted. Appointment of so and so made by order dated 25/10/2024 stands confirmed. The parties will serve a copy of the order before the arbitrator and will appear before the arbitrator on 26th of June, whereupon the arbitral tribunal will proceed to decide the matter as per law. Disposed.
That 7/3/2000 when notice was issued, into that they did not file any counter affidavit.
Yes.
The affidavit has been sent, my lord, day before yesterday for swearing and getting. I am seeking a short accommodation, my lord. It will be fine.
Mr. N. Bora for the petitioner, Mr. R. Bopuzari for the finance.
Finance, my lord, for respondent 1, 2, 3, and 4.
One correspondent, 1, 2, 3, and 4.
My lord.
Submits that the affidavit will be filed within a period of 2 weeks. Okay. Accordingly, let the matter be listed again after 4 weeks, enabling the respondents to file their counter affidavit. Stop petitioner is also permitted to file rejoinder to such an affidavit as may be filed with the respondent, if so advised. Mr. B. Sharma appears for the accountant general. You complete your pleadings, then make a mention.
July last part.
No, you file you first let us see whether they file it within the period. If they file, then you will file your rejoinder. List on 3rd of August.
Much.
So applied.
Much.
Please, my lord, here, my lord, the petitioner's claim for, my lord, benefit of earned leave, my lord. Now, the respondent number 2, managing director, has filed one affidavit in item number 34, my lord.
And this,
So,
this will cover all the 3 cases.
In that case, my lord, to that affidavit, I would like to respond, my lord, by filing my reply. But,
Mr. B. K. Das for the petitioner, Mr. S. Bora for the respondent. Mr. Bora submits that an affidavit has been filed in WPC
6807 of 25.
6807 of 25.
cover all
And the said affidavit we cover suffice for the other 2 petitions. Stop. Counsel for the petitioner therefore submits we would like to file in rejoinder. Prays for 3 weeks time. Is the matter again after 3 weeks. Yeah.
Proceeding in this case, the present petitioner, he approached before the honorable court for regarding his transfer matter. Right. He was initially appointed as a physically disabled person, and in the year 2020, when he was going to discharge his duty in Bongaigaon district, he faced a road accident, and therefore he got several injuries, and he is not able to maintain a journey from Borpeta to Bongaigaon district, and he is not able to ride any bike or car due to his.
Is there any document to say that you are physically disabled?
My lord, yes, certificate I have.
Where is that?
At page 24, you know. And operating part 25. Place of duty about 100 kilometers distance from his.
What is the benchmark disability? Otherwise,
Yeah, 45%.
45%.
Case accident, he has been suffering various problems.
Yes, respondents.
Communicated, but presentation perhaps can be over sometimes.
Is there a representation pending?
Yes, madam. 19/6/25.
Page?
Page, your lordship, that's 35.
35. Is it possible that you can consider this?
Madam will see page 35. It is not a signed one, man. 35, 36. 35 is the type could be 36 also, madam. There is no signature.
Signature.
Submitted another representation. Actually, he submitted and sent me in WhatsApp in lordship, and another representation in lordship at 37.
Head representation, we can issue directions to consider. It's not your departmental head. You are a government servant. You are a government servant.
Minor.
So you have to represent before your superior authority.
Yes. It is a health service. It was, but unfortunately, some
Mr.
mistake
B,
is there.
overturned additional age is permitted 4 weeks time to complete instruction. You're Mr.
Emi Ahmed.
Emi Ahmed appears for the petition. It's after 4 weeks. Let him get instruction.
Fine.
The instructions in this matter, Lord. Some time may be granted to.
None appears for the petitioner involved. Mr. H.
R. Das.
Huh?
H.R. Das.
H.R. Das appears for the respondent, submits the instructions that have been received. You'd like to bring it by way of an affidavit. Prays for 4 weeks' time. Prayer made is allowed. List after 4 weeks. Yeah.
Maybe the doctor. They are supposed to file the affidavit, madam. Yes, my lord, our draft affidavit is ready, my lord. I have sent it. Last time also we have checked. Signature, my lord.
Mr. S.P. Das for the petitioner, Mr. TC Sutia Learned
Additional
State Council submits that the affidavit will be filed within 2 weeks.
2 weeks.
Let this matter be listed after 3 weeks. In the event any affidavit is filed, petitioner is permitted to file rejoinder if so advised.
This is a case of dismissal manner from service without serving the report manner. And our co-accused is in serving manner service.
July,
Yes, ma'am.
17 July. It's on 17 July. Before vacation, July.
My lord, the matter pertains to regulation of service, my lord.
Our instruction. Kindly read 2 weeks time we will grant. 79.
Mr. B.K. Sharma for the petitioner, Mr. B.C. Musahari pays for the PTC authority, renews his prayer for further time. He prays for
After summer.
3 weeks time. Considering the prayer made, release this matter again. July. 20 July.
In this case, my lord, on 2nd of March, they issued the instruction. Now, several months have passed, but they have not filed any affidavit or my lord. Lordship, I have received the instruction. The for finance department. Petitioner's case has been sent to the finance department for SI approval, Lordship. Some time may be required, Lordship. The process. It is under process, Lordship. Proposal has been already sent. Point number 3.
Point number 3.
Lordship.
What is that?
Agriculture Department subsequently submitted a proposal of compulsion and appointment in respect of the petitioners to the Finance Department for SI approval.
This is not what you are giving me, something else.
Sorry. Point number 3, Lordship.
Same instructions. Point number 3, something else. Point number 3,
Bottom line,
agriculture submitted, okay.
Lordship.
Submitted proposal for compulsion and petitioners for SIU approval.
Lordship.
Who's for finance? Finance department?
Finance is not a party. Party here, remember? This one, hi.
Ms. G. Boral and Standing Council Agriculture has placed before the court the instructions received from the department to the effect that the Agriculture Department has forwarded the proposal to the Finance Department for SIU approval. Mr. A. Choliha, Learned Counsel for the Finance, will apprise the court as to the status of the proposal stated to have been forwarded to the Finance Department for SIU. MS N. Soikia, who the petitioner, release this matter again after 3 weeks.
Not in July, my lord. The date may fix in June itself, last week of June.
Last week of then 2 weeks.
25th of.
Let's see, these are the last week will be for motion days.
Motion only.
Relisted after 10 days, list on 19th of June.
Obliged. 19.
And it's there in the government.
Yes, I have.
Mr. J.K. Goswami.
SLC.
PS for the
SLC.
SLC. SLC is respondent number 2. Please inform the finance department that we want the instructions.
Obliged.
Please, your lordship. Lordship, this matter relates to suspension, your lordship. Deepak Mali and Ajay Chaudhary case is applicable. And last occasion, my senior honorable court was directed to take instruction whether that charge or if it was made within 90 days.
Yes.
I have not received any instruction. The matter is suspension by Lord Governor. So Governor suspension, again appointment suspension, we said the appeal provision is there. Appeal provision is there. Lordship can see executive instruction. Executive instruction 162. There is a appeal provision. 162C. These are the provisions. And this instruction is made after the Supreme Court passed an order in Kondorpo Sharma. The Kondorpo Sharma case, direction was given to the state government to frame certain condition and service condition of the Lord Governor.
There is an appeal.
So he, but dispose of he can appeal.
My lord, appeal can file. I've gone through that Kondorpo Sharma. Yes, because my lord, Kondorpo Sharma says this is the Gambura post, is a civil post. It is protected under Article 311, your lordship. Lordship, in this particular, that appeal provision when applies, my lord, that first they also this case, question was arises when that my lord appeal provision in while when suspension order is. There is a case, my lord. They have not issued any suspension order till to until and unless I have not received any suspension. How can I file, my lord? Kindly look into my.
You are not allowed to work.
No, my lord. Neither they allowed to work, not my lord, suspension order issued to me, my lord. And my lord, Arthur Rahman is said that when somebody is, my lord, beyond 48 hours of the custody, my lord, it is automatically, my lord, it is deemed suspension in case, my lord. Now question is.
Your prayer is for to withdraw the suspension order.
What happened, my lord? As per why I am meeting, they are not allowed me to join in my flows, my lord. I have made a representation before that, my lord. Now, my lord, as per that Arthur Rahman judgment, 66(2) of the Assam Civil Service Discipline Appeals Rule said, my lord, that if somebody is in custody beyond 48 days, it is deemed suspension. So, my lord, and the Arthur Rahman judgment is clear, my lord, says that though even that suspension order is not issued, then it is automatically suspension. Now, my lord, they are hanging, my lord. Neither allow me to join, my lord, nor they issue the search sheet or remove my suspension, my lord. Where I have to go, my lord?
If there is no order, why he is not joining?
My lord, kindly look into that, my lord.
He is not allowed to.
Page 40, my lord, in my petition, my lord. Kindly look into, my lord. Annexure C, my lord. Page 40, lordship, Annexure C, lordship. Order dated 20 July 2025.
But this is a suspension order.
No, my lord. Yes, the inquiry was there. I pursuant of the pursuant of suspension of Sri Devadole Lord Governor so Revenue Circle dated of his arrest by Tinsukia Police PS case number Sri Jolie Das Asia's Assistant Commissioner Damaji is hereby entrusted to conduct an inquiry and submit a report to the undersigned at the earliest. They are not still now, my lord. I don't know, my lord, whether they suspend
The order says in pursuance of
yes,
suspension.
my lord, deemed suspension. So neither review, nothing, my lord. The question of law is involved here.
No, so you go and file an appeal before the authority. Why the suspension is
My lord, that copy was not served to me.
The copy, if they not served, then take this ground as a before the appellate authority. There is an alternative remedy.
But my lord,
Unless it's a question of law, or very strong issues about violation of natural justice, etc., then, you know,
But my lord, this is not a suspension order. Holding
no, this is not a suspension order, but
He
it
paid for without a
refers to a
suspension.
suspension order,
My lord.
right? So you have the option to file an appeal to say that
I was not filed an appeal because my lord, as on today, neither suspension orders communicate to me until and unless if that order is not communicated, higher come to me. I have got this letters from my source man. That's my.
so this is the issue to be decided by the appellate authority, whether furnishing of, without furnishing an order, whether you can be placed under suspension.
A good count.
That is the issue to be decided by the forum, either by the court or by the appellate authority.
Now, my lord, when I work here to this my lord, they said that some inquiry is going on. Till complete of this inquiry, we cannot do anything. So now I am hanging my lord. This is the main thing, my lord. Neither suspension order issued till today, nor reviewed, nothing, my lord, not allowed me, my lord.
So you because these are factual issues, go and urge your case before the authority.
So, my lord, direction they decided to decide that my appeal within a period.
First, you have to file an appeal.
I will file, my lord. I will do 15 days, my lord. I will file.
You have to file an appeal.
But my lord, that much also there, my lord. That is why I am not going to that file that. I have not filed that appeal, my lord. Only because of that suspension order is not completed.
I will go and file appeal.
Now, what is this, Mr.
My lord.
Sutia? Why have you not served the suspension order?
But it is not informed to us, my lord, by the authority. Perhaps they have issued, my lord, he may not get it. He in his prayer, he already mentioned the suspension order. Now, where he has come from, that the suspension order is there. If it is not suspended, he go for appeal, otherwise to allow him to join. Otherwise, file a reputation, my lord. Why I have not been given the, allowed to join? May not be appeal. But he not approached the authority, he's come to the court and saying that it is applied to other authority case, not review. But there's the alternative, but the executive instruction specifically said. This executive instruction is made as per controversial case, my lord, Supreme Court directed as per paragraph 21. So accordingly, my lord, there's terms and condition that has been, my lord, incorporated in the executive instruction by amending the executive instruction. Now, my lord, lordship may dispose of it, my lord, let him file a my lord, representation before the authority.
I may be allowed to place that hurtful amount judgment.
For what purpose?
Oh, regarding that suspension, yes, that its particular situation was arises, my lord, in this case also, my lord.
What is that situation?
That was said that on the other hand, Rule 6.2 is automatically invoked when the government employee is arrested and detained in.
This is for counting the period. 90 days.
Yes,
Is it?
but my lord, there regarding if somebody is with a suspended order not issued, then what will be the effect? That
What?
part also.
What is there?
My lord,
You read it.
my lord. On the other hand, 6.2 of automatically invoke when the government employee is arrested and detained in custody beyond 48 hours. By operation of law, such a detained employee is deemed to have been placed under suspension from the date of detention. Because of this deeming provision, even formal order of suspension need not be issued. Here is if suppose my lord, suspension order is not issued by the department, then it will be automatically suspension order.
Then why are you not going in appeal?
But my lord, here is a case, my lord. That is why I am coming before your lordship. When I filed the representation before to allow me to join, because my lord, they are not issued the such. No, my lord, reviewed my lord, suspension period. My lord. Now they are. I am hanging, my lord. They said that we cannot.
Let us understand your submission. Are you aggrieved by the suspension order, or you are aggrieved by the fact that it was not reviewed, or you are aggrieved by the fact that in spite of being under suspension for a certain period, no proceedings have been initiated? What are you aggrieved with?
My lord, here is a case. When my lord, my petitioner is that, my lord. When he went to the office, my lord, after release of the jail, my lord, he went to the my lord office, my lord.
So you are aggrieved by non-communication?
No, my lord.
Then?
But suspension, my lord.
Suspension. Then go and file an appeal. Go and file an appeal. Well, you accept that in terms of the judgment, your suspension will have a deeming effect. And even if copies are not issued, it is suspended. You agree? So you have a right of appeal. You should go and appeal.
My prayer is, my lord, can be, my lord, this way can be.
Your prayer now would be to convince the court that in spite of the alternative remedy, why the court should intervene in this matter. If you satisfy the court, will intervene it. Otherwise, you have the remedy of filing an appeal.
I was not, my lord, filed an appeal only because of my stand understanding, my lord, because, my lord, suspension order not issued to be.
But you are reading the judgment.
No, that's true, but my lord, this is another aspect, my lord. When I went there, my lord, then circle officer said, no, you are not suspended, but I cannot allow you join because a inquiry was, my lord, going on. So that is the position. So I am in an angle, my lord. That is why I am not going to file it. That was, I
Then
have
you
not.
filed a representation. Have you filed any representation?
Yes, lordship.
Where is that?
Page 48. I still revision, my lord, 25th, 8, 25, after I would like to inform you that on 16/7/25, the Tinsukia police has arrested me by from my residence in connection with PS case number.
This is not signed, this is not received.
No, my lord, next page is there.
Where is it?
49.
49 is also not, it is not shown to be received by the
My
department.
lord, they are not giving the receipt, my lord. That's the another aspect, my lord. They are not also not denied, my lord.
Huh?
They are also not denied that they have not received any representation. That is the fact, my lord. That I am an employee, my lord. Then what can, my lord, before the authority, my lord? If not, they are giving any, my lord. I am a Gambura, my lord. I cannot mind beyond my.
If as a Gauhati you do not know the provisions, then what responsibility will you undertake against the village? You are the wisest man in the village.
Yes, I am the Gambura, my lord.
Not the
But
Gauhati,
no,
you are the
my lord,
wisest.
if
You are
when
the
I
wisest man. You are
when-
supposed to know everything. Therefore, you are a Gauhati.
that's why I know, my lord. But my humble submission before your lordship that when I went to the
See, you went there, you filed some representation, there was no response.
Yes.
So you are confused that whether you are suspended or not suspended.
Yes.
But you are holding on to a judgment which gives an interpretation that it's a deeming provision, even if not served, you will be under suspension. So under that judgment, you are now deemed to be under suspension with the effect from the date you were taken into custody for more than 48 hours. Now the statute has a remedy for you to file an appeal. You have not chosen to go there, decided to come here, but you need a strong reason. Allow the court to interfere in this matter, notwithstanding the alternative remedy. You have to make out a case that it falls in those exceptions.
My lord, why I have come here, my lord, I have going to the appeal. Appeal because I have not filed, my lord, no communication was made, my lord. And my lord, I am also confused, my lord, whether my
So we'll
suspension
clear that confusion right away. You go and file an appeal. Because you are relying on a judgment.
Yes, that's true. I understand,
Which
my
gives
lord.
that interpretation.
My lord, I understand, my lord. That is why, my lord. One hand, my lord, I have protected under conservation my judgment. I have gone through that, my lord. And now question, that is some situation is sometimes happen, my lord. This is the situation where, my lord, I understand that Deepak Mali and Ajay Chaudhary, all those things, my lord.
Deepak Mali is not applicable to you.
But Ajay Chaudhary is there.
Ajay Chaudhary may not be.
But my lord, here is a case, my lord. Neither if there should be suspension, then definitely I have to within that appeal figure.
Yes, Mr. Chutia.
Yes, my lord, because his PI is against the suspension order. He can go, he interpreted.
You have not issued the suspension order.
Suspension order, he may issue or may not issue, I don't know. He interpreted it, but not deemed to be suspended. then according to him, my lord, he is admitted that he is suspended. So he can go for appeal.
I am not admitted, my lord. As per this honorable judgment,
You are,
my
you
lord,
are
court
interpreting
judgment,
this
my lord.
order.
But you have prayed for setting aside.
Yeah, that is why, my lord. As per this Arthur Rahman judgment, I am placed. That is why, my lord. Let them say, my lord, whether I have been placed, my suspension order
How
was
does it
issued.
matter? You have made a prayer for withdrawing the suspension order,
Yes, my lord.
right?
Yes.
So you know that you are under suspension. You are fortified by the judgment
Yes,
of the
sir.
coordinate bench. Now, how does it matter for them to say whether you are suspended or not? You have already interpreted in their favor that you are under suspension
Yes.
by making a prayer,
So,
by
alternative
relying
of-
on the judgment.
So, my lord, another alternative prayer also there, my lord. But can always or your lordship have a power, lordship, to give. That is why, my lord. Can oblique or is there, my lord. Lordship have a ample power to, my lord.
All right, Mr. Sutia, please inform us what are you going to do? Are you going to keep him under dim suspension for eternity?
My lord, may I submit one thing? Lordship may direct them to file an appeal. Then accordingly he will file appeal, my lord. They will respond.
They are not responding to you.
No, they will respond then, my lord. Your lordship
So you get some instructions and tell us what steps are they taking towards, are they proceeding for any inquiry or
any
investigation?
passing any suspension order or not.
No, assuming the suspension order is there,
Yeah.
it's not a punishment.
Not punishment.
So it is for a purpose of drawing up a proceeding or maybe criminal proceeding is there. What is the status? You have not filed any affidavit also.
No.
Get some instructions.
Then after 2 weeks.
Mr. K. Das for the petitioner, Mr. T.C. Futiala, Senior Government Respondent number 3. 5, Mr. S. Das, S. Dr. 1 and 2. Petitioner is stated to be deemed under suspension with effect from the date of his arrest on
Yes, sir, my lord.
16/7,
2025.
2025. Subsequently, he was released on bail on 23/8/2025.
My lord, he released on jail on 23.
23/8/2025. However, he was not allowed to join in this. And the department has also not served any order of suspension petition. Being aggrieved, he has approached this court. The state will apprise the court as to the steps undertaken in respect of the petitioner as to whether any proceedings are initiated and are pending or whether any suspension order was issued and served on the petition. Released again after 3 weeks. 20 July.
The respondents have filed their affidavit in opposition yesterday, my lord. I need some time to file a reply. A date may be fixed, my lord. I need only 2 days. to file a reply.
It is then for the petitioner, Mr. D.K. Burwa appearing for the SBI. Is submitted by the counsel to the petitioner that the affidavit has been filed by respondents 345. 345. Any affidavit necessary for 1 and 2?
Only for notification and they have.
The term appears for respondent 1 and 2. Consider the counsel for the petitioner submits that she would like to file a rejoinder to the affidavit filed by the respondent 345. She prays for how much time?
My lord, next week, I need.
Next week.
Yes, my lord, before vacation.
The listed after 1 week.
A fixed date needs to be given then.
18th June.
highly authorized.
List accordingly. Yes. I don't think. Yes.
John, but if it is not filed by the respondent for some time.
4 weeks time.
Mr.
P. Panika, behalf of
P. Paniga appears on the behalf of the petitioner.
just border.
Mr. K. Kumar, learned additionally appears for respondent. Prays for 4 weeks time. Yes, sir. To file the affidavit.
For summer vacation.
Before summer vacation, not possible. Let the matter be listed immediately after reopening, July. On a date to be fixed by the registry.
But I have received an instruction from the commandant of 27 of his battalion. It is not sufficient to file affidavit because he is a case of promotion. I will have to file from the IGP administration. Sometime they will be granted. Copy was directed. I have not seen here the copy is up to the officers. I have.
Extra copy is not furnished.
They have furnished, but perhaps concerned advocate did not furnish it to the authority. Or sometime maybe gather, but not individual. I will get that stuff.
Mr.
Yeah,
Ahmed appears for the petitioner. Mr. T.C. Sutiel, an additional senior government advocate, appears for the respondent. His prayer for further time and instructions are not complete in order to enable make it, or in order to enable him to file the affidavit. Reduce his prayer for 4 weeks. Release this matter again after 4 weeks. Interim order passed early will continue, if any. If any. Yes.
The order 13/5/26.
Yes, any instructions?
Also, we have instruction, we will have to file affidavit.
Mr. P.K. Roy Chaudhary, learned senior counsel, assisted by Mr. A.K. Azad. The petitioner, Mr. K. Kumar, additional AG, appears for the respondent, submits that
10 days time may be given.
instructions have been received.
Yes, 10 days time may be given.
He prays for 10 days time. Yes. This matter again after 2 weeks.
The date may be fixed.
24th. 25th. Oh, this is the last week. Last week.
Yes.
Last week is not possible. May not like to fix matters.
So after.
Let it come immediately after vacation.